Hello, this is Gail Strack. I'm the CEO of Alliance for Hope International. Thank you so much for joining us today. We have a very special webinar. In fact, I'm going to ask Trish to advance the slide. Just want to give you a couple of housekeeping information that might help the experience of this webinar work more smoothly. A couple of things that we have. We would love to have your feedback at the end of this particular webinar. We're going to be talking about forfeiture by wrongdoing. Not only do we have an evaluation, but we also have the opportunity to send in your questions for our speakers. We're going to give our speakers as much time as they need to share the information that we have put together for you today. So to that end, we have a chat feature where you can start writing in your questions. And if anything is not working, just let us know, because under the category of technical assistance, we have a number of staff members on site ready to go to answer any questions that you might have, or if for any reason you may not be able to hear us or see the slides. And speaking of the handouts, we have a nice long list of handouts for you, starting with the Cody case, PowerPoints, and other resources that have been provided by Equitas and the National District Attorneys Association. Next slide. So to make sure you're at the right webinar, this is Forfeiture by Wrongdoing, Turning the Tables on Witness Intimidation. And I have to share with you how excited I am about this particular webinar. Some of you know me and all the work that we've been doing in the area of strangulation, but when the Cody case came out in 2018, I have been talking about that case ever since, telling everybody they have to read it. And even all of my law students, we spent a good chunk of time talking about the Cody case. But what excites me is the most is now we get to bring the Cody case, which is really about evidence-based prosecution, to all of you and the lessons learned from our friends in Virginia. But before we go deeper there, and I share a little bit more about why this is so important, right now you see a picture of me, Gail Strack, and Casey Gwynn. Casey Gwynn will not be able to join us, but I wanted to honor Casey because Casey was our visionary and our champion in San Diego when we started evidence-based prosecution back in 1989. That's right, the late 1900s. So to see evidence-based prosecution live and well in other jurisdictions and people who are absolutely passionate about this and committed to helping victims of domestic violence, it is really a special day for me. But Casey Gwynn was our elected city attorney. We modeled evidence-based prosecution and the techniques that were initially designed and kind of thought through in Duluth, Minnesota. And Casey went to Duluth, Minnesota, met Ellen Pence and prosecutors who were experimenting with evidence-based prosecution and brought it back. And then in San Diego, back in 1989, we had a very thoughtful discussion with our domestic violence community about the benefits and the challenges with it. But I have to say is that since we started it, great things have happened. We've been able to drop domestic violence homicides dramatically. At that time, we were averaging 30 domestic violence homicides like clockwork. But through that journey and where we are now, this last year we averaged, well, we had 3 domestic violence homicides. So to go from 30 domestic violence homicides like clockwork down to 3 in a population of 1.3 million people is amazing. And I'm very proud of all the work that San Diego and our community did together. As our speakers will share, to get to that point, it takes a lot of hard work and also takes leadership, support from your leadership, committed professionals who all work together as a team. And at the end of the day, I truly believe it matters and it saves lives. So we will continue because our speakers have a lot to share, and I'm really proud of the work that they're doing. I'm also very proud of the fact that we have the support of the Office on Violence Against Women. We have a new director, acting director, Laura Rogers, who's actually has her roots in San Diego as a prosecutor. You also see a picture here of Kevin. Kevin Sweeney is our program manager, and very supportive of our work. So I just want to say thank you. Thank you to OVW for giving us this opportunity to identify great topics, great speakers, and bring this information to others. Today, I think we have over 400 attendees who have registered for this particular course. I suspect most of them are prosecutors, along with some advocates and police officers who are involved in the trenches in the front line each and every day. Next slide. I also want to give a shout out to our team, because putting these things together and sharing it with you is no easy task. But I've already had a chance to introduce our leader, Casey Gwynn. I have two other individuals that I want to introduce before I get to the next slide. One is Dr. Bill Smock, who leads our medical team and has been very critical in advising us in our area of strangulation. And then most recently, Dr. Chan Hellman, who has joined us to really think through and do some more research, especially in the area of science of hope and how we can integrate that into our work. But he's now helping us on doing some focus group with survivors of strangulation. So stay tuned. Between the two of them, they will help us continue to learn and advance our work. Now the next slide. And behind the scenes, managing all the technology, we have two amazing people, Trish Middleton and Carly Gersberg, and they are part of our strangulation training team. They help us each and every day, right arm and left arm, right there on that slide. So I can't thank them enough for all that they do and all the worry that they take on with respect to the technology piece. I'm not strong in technology. As I have someone else do it is fantastic. And a little bit more about the Training Institute on Strangulation Prevention for those of you who may be new to our webinar today. This is a project that actually was launched in 1995 unofficially when two teenagers died. And we set the course to never let those two teenagers die in vain. And I'll talk about them in a minute. But also just want to acknowledge that through the Office of the Department of Justice and OVW, we launched the Training Institute officially in October of 2011. And we've had the honor to be able to continue to do this work and bring on other experts and share with you some amazing resources. So hopefully it will make your job a lot easier as you continue to do this work. Next slide. And if you haven't visited our website, I would encourage you to do so. It is at strangulationtraininginstitute.com. There you will find out about upcoming trainings and webinars, but we also take great pride in adding new resources and materials, news stories, and case law and statutes onto our legislative map. So spend some time there. You'll always find something new, guaranteed, because that's something that we promise to do. Next slide. And before we get started, I just want to again honor Cassandra Stewart and Tamara Smith. When I was sitting in Alex's shoes many years ago, running our domestic violence and child abuse unit on behalf of Casey Gwynn and our city of San Diego, I had two teenagers that died under my watch in 1995. They were the first two homicides to occur that particular year. And it was a year that our DV community, we were working very hard to be one of the largest cities in America with no domestic violence homicides. It is still our dream. We haven't made it yet because, as I mentioned, we've been able to get it down to 3, and 3 too many. But when these two teenagers died, it really changed my life forever. Since I was in charge, I say it happened under my watch, and it was my responsibility to figure out if we could do a better job. Could we improve the techniques and the protocols and the trainings that we have already put together to do a better job? And the answer is yes. To tell you a little bit more about Cassandra, she was 17 years old at the time that she was stabbed to death in front of her girlfriends. And 2 weeks before she was killed, she had called San Diego Police Department to report that she had just been choked. Sadly, we did not have enough evidence, we thought, to prosecute this case, because at that time she was recanting and minimizing. We had no photographs. We literally had no cooperation or support. So the case was canceled and never submitted for prosecution, and 2 weeks later she was dead. Tamara Smith died a month later. She had been strangled to death and then set on fire by her boyfriend, left there on a dirt road to be found by her mother. And when I heard about that case, it just really broke my heart. And then I found out that Tamara, too, had a history of domestic violence and, in particular, strangulation. One month before she was killed, she, too, had been choked, as we used to call it. And that case also did not get prosecuted. So that led us on a journey to find out what more do we need to learn and do to prevent this from ever happening again. Since then, a lot of changes have taken place. And when you hear more about the Cody case, you'll understand why I'm so excited about what they've done, where we are going, and how cases today can be proven without the victim's testimony and with very little evidence in a strangulation case. But it takes time, work, and teamwork. So thank you again for joining us today for this very special webinar. First, what I want to do is introduce you to Alex. Alex is the lead attorney that oversees their domestic violence, sex crimes, child abuse, and elder abuse unit. And I particularly begged her to be on this call because she wanted it just for her deputies to share the story. But I think part of the story is leadership, is having somebody who understands this issue, cares about this issue, is passionate about it, who identifies good deputies, passionate deputies who want to be in the unit, who then can support them with the vision of their office, the support that the office can bring, and continue to push the envelope in these very difficult cases, and hopefully make a difference in your community where more victims stay alive. Because without intervention, it's too easy to drop these cases, dismiss these cases, and not fight for them, especially when victims appear to be uncooperative, unhelpful, recanting, and they may even call you names unless you drop the case. So that is a story I think everybody on this call truly understands. And thank you for joining to figure out what more can we learn, especially in the area of forfeiture by wrongdoing. So Alex, thank you for your leadership. Thank you for joining us. I'm going to give you the honors of introducing two of your prosecutors who are leading the way in America.
Well, thank you so much for having me. It's an absolute honor. I sort of feel when I'm anywhere near or speaking to Gail Strack, it's like I'm around Bon Jovi. So, so much, Gail. It is really, truly my pleasure. And I really feel like all of the honor is due to I call them my boys, Joshua and Donald, but they certainly aren't boys. Josh, until very recently, worked for me. He has now left and departed for the greener pastures of Wichita, Kansas. But he has, until very recently, worked for close to 9 years in the Commonwealth Attorney's Office. And out of the 9 years, he was, I believe, in our unit for 5 of those years.
Donald, 4 maybe.
And Donald is a senior assistant Commonwealth attorney and has also been in the office for close to the same amount of time. And both of them came down, volunteered to come down to the domestic violence unit at a time when most people didn't have much interest in working domestic violence cases. And usually it was considered a 2-year rotation and then people were ready to leave. Both Don and Josh came down to the unit and really to it and like ducks to water, and developed a passion for this work, passion for protecting victims of all kinds of crime. They do domestic violence, sex crimes, child abuse, and elder abuse. And they very quickly, despite obstacles such as perhaps officers didn't always have the greatest training and judges that were very tough on them, they decided that they were not going to be deterred, and they have never failed to amaze me in their ability to think critically, to think outside the box, to be passionate about their victims, and to just never be other than enthusiastic about their work. And because of their critical thinking, their out-of-the-box thinking, that resulted in the Cody case. And I could not be prouder of the work that both of them have done in this unit. And like I said, that resulted in the Cody case, which I am very proud of, and that I had very little to do with other than to sit back in the sidelines like a proud mother and clap for them.
Well, thank you, Alex. We really appreciate you being here, as well as Josh and Donald. So let's go ahead and jump in and find out what everybody is talking about when it comes to the Cody case. So Josh or Don, who's gonna?
Sorry about that. So first of all, thanks, Gail. Thanks for letting us have this opportunity to talk about this case and this topic. And thanks, Alex, for your kind words. I miss you a lot. I love my new office, but it'll never be quite like the office there in Loudon. But Commonwealth v. Kevin Cody. I got to say, first of all, all praise to Don, because ultimately this was his case. Forfeiture by wrongdoing is certainly an issue that we were working on together, and we've worked on a lot together. But he's the one who got it past the finish line into the Court of Appeals in Virginia and got some great case law. So I got to say, just all praise to him on this one. So let's start talk about what is forfeiture by wrongdoing. Now, I think most people know that criminal defendants have a Sixth Amendment right under the U.S. Constitution to confront the witnesses against them. And there's the doctrine of confrontation has gone back and forth over time, but where we are now, it's in the law is really dictated by a case called Crawford v. Washington, and that's from 2004. And in that case, the Supreme Court overturned I'd say many decades worth of precedent in saying that a defendant has the right to confront the witnesses. And what that means is he has a right to confront a witness regarding their testimonial statements through cross-examination. And a testimonial statement, as they clarify, is one that is made in contemplation of criminal prosecution. Basically, any statement a person makes where he might reasonably believe that it would be used in a criminal prosecution and has actually had a chance to consider that possibility. So some classic examples would be excited utterances are not considered testimonial because by definition, they're made in the heat of the moment. You haven't had a chance to actually think about what you're saying. So of course you haven't had a chance to think that this might actually be used in a criminal prosecution. On the other hand would be an interview with a police officer. They're there, they're asking you questions, you have a chance to think about what you're saying, and that's going to be the majority of the statements we have in our criminal cases. And those are almost always going to be considered testimonial. So you can't put those statements into evidence without having that person, that declarant, on the witness stand and able to be cross-examined and confronted by the defendant. So in cases of forfeiture by wrongdoing, the defendant gives up that right of confrontation, and it's based on what I'd call an ancient maxim that a person can't profit by his own evil act. Therefore, a defendant who causes a witness to be unavailable can't then complain that he was denied his right to confront that witness. And then we don't actually have a slide on this, but I'd say maybe more importantly for practically speaking in what we do is forfeiture by wrongdoing is also a common law hearsay exception. So even if your rules don't specifically talk about it, the federal rules actually do have a specific hearsay exception for forfeiture by wrongdoing, but a lot of state rules don't. You can look at the case law, look at Crawford, which talks about forfeiture, look at Giles as well, and you can glean from that there's also a hearsay exception. I know Don will talk a little bit more about that as well. So the question then is, how do we prove that forfeiture by wrongdoing has occurred? There are three elements to it, and they're really pretty simple. The first is, you can see on the slide, that the witness is unavailable to testify. And we'll talk a little bit more about what unavailability means in a bit, but the classic example is just simply the witness isn't there. It doesn't show up for trial even though you subpoenaed her. The second element is that the defendant had to have caused that unavailability. And I would also note that his mere acquiescence in when other people are causing it. So, he's talking to somebody and they're saying, oh, we're going to make sure she didn't show up. And he says, great. He maybe doesn't actually take any direct act, but he knows it's happening and he allows it to happen. That could also be used as well. This is probably going to be your hardest element to prove in most cases, or sometimes it's so blatantly obvious that even a first-year law student could do it in court without breaking a sweat. But generally speaking, that's where the case is going to rise or fall, is on this element. Then finally, the third element is that the defendant acted or acquiesced with the intent to prevent the witness from testifying. And this is the element, I think, where a lot of people will actually get confused, because it all seems like it makes sense until you get to this one. And the purpose of this is that it's not necessarily a wrong act in and of itself without that intent to actually prevent the witness from testifying or prevent the witness from being available. And the hypothetical I like to use, or the example I like to use for this is, let's say a husband gets arrested for beating his wife, and he's taken to court. He's arraigned on the charge. Trial date is set. Before the trial date, they go out to dinner, to patch things up, try and make a bet, go at it. And on the way to dinner, they get into a car wreck and his wife dies. Well, she's not going to be available for trial at that point, obviously. But this isn't going to be a forfeiture case, because unless you can prove that he intentionally got into that wreck with the point of, either killing her or injuring her to the point that she couldn't come to testify, it's not a wrongdoing necessarily, even if he was drunk and, driving when he shouldn't have been. Unless you can show that his intent was to actually prevent her from being available, it's not a forfeiture case. And I guess now I'll turn this over to Don, because he will talk about the Cody case itself, and we'll go into a little bit more depth about how he was able to prove it in a specific case, and then I'll wrap back up at the end and talk about more generally speaking how you can apply this doctrine to your cases.
Right, and this is kind of the real point of this whole presentation, is this slide right here. We talk about forfeiture and how interesting the history is and how important it can be, but this is the question everyone always wants to know. Well, how do you actually do it? And that's literally the only answer there is a lot of work. Everybody in the process, from the first responding police officers or EMTs all the way to the prosecutor in court, and even the judge, and have to be willing to consider things that in your average case you just don't have to consider and you don't have to look at. So it's important to make sure that you do your training to your victim advocates, with your first responders, whichever ones you can get, especially your police officers, and the other attorneys in your offices, to understand that these cases are not going to be routine. No matter whether you're able to make their forfeiture case or not, it's not going to be routine. Everyone is different, and everyone requires a different kind of work, but they're all going to require a lot of work to make the case that you have to make. So the case we're here specifically to talk about is Commonwealth v. Kevin Cody, and this is Mr. Cody right there. That's his booking photograph. It was we looked really hard at the Kevin Cody case because of a couple things that really stood out in the police report, which we'll talk about in just a minute. But to give you a little bit of background, Kevin Cody and the victim, who I'll just call her Rain, because that's her nickname, and there's no need to embarrass the poor woman with throwing her real name around, had been living together for 6 or 7 years. They had 2 children in common, and at the time this happened, the oldest was 5. Typically the children were present when the abusive incidents occurred. Mr. Cody was a personal trainer. He was in very good shape, very strong. Rain is a massage therapist, and as one could expect, for a very controlling person like Mr. Cody, that caused a lot of angst. There was a lot of physical contact in her job. He was constantly convinced that she was cheating on him when she was at work, and that's what led to this current instance. So that's the background, and that was what was going on. And when Rain got home a little late from work, about half an hour late one day, and Cody was already there, that's when the strangulation and the beating that she experienced that finally led her to call the police occurred. And if we could go to the next slide, we can hear that that 911 call. It's we're going to play the whole call for you, and we'll talk a little bit about how important those calls can be afterwards.
January 15th, 2016, 17 hours, 10 minutes, 41 seconds.
Loudoun County 911, what is your emergency? I'm leaving a very dangerous man and I don't know where to go. Hold on, let me get the sheriff's office on the line.
Sheriff's office, what's your emergency? Sheriff's office, what's your emergency?
I'm in the process of leaving a very dangerous man and I don't know where to go. I'm sitting in front of the sheriff's office. It's closed. I need to report him. I need to find out what I can do.
Okay, what do you mean you need to report him? What happened?
I have bruises. He's been kicking me and hitting me, and he's choked me to the point of passing out for the second time in 2 days. This has been going on for many years. I just packed up and left because he's at work right now. I don't know what. He left around 4 o'clock. I packed the kids and myself up, and I'm in my car.
Okay, and where are you located right now?
I'm sitting in front of the county sheriff's office.
In Sterling?
Yes.
Okay.
I have 2 small children in the back seat. I haven't explained anything to them.
Okay. All right, I want you to wait there, and I will send an officer over to meet you, okay?
Okay.
All right, they should be there shortly.
Thank you.
You're welcome.
Okay, so that's obviously not a short call and a short recording. It's not difficult to play for the jury if you end up going to trial, but it's vitally important. And I find that in these cases, those 911 calls are some of the best evidence you have. The 911 call puts your fact finder in medias res, as the English classes say. They let your judge or your jury put them right at the incident, right when they can hear the victim, when the trauma is fresh on her mind. That can be extremely important, especially if in this case, your victim recants or your victim refuses to speak about what happened. It's also especially important when your defendant is trying to say that your victim's fabricating what occurred, because if you can put that fact finder right there and hear how this was affecting her at the scene when it happened, it's going to be very difficult to credibly claim that she's making that up. And at the very beginning of that call, especially, I think you can hear the fear in Rain's voice, and you can hear the desperation she has to get some help, to get away from what happened to her, and that can be an extremely powerful point to make in any domestic violence case, but especially when you're having to present a case without the testimony of your victim. So the police came. She met with them at the sheriff's office, as you heard. The deputy in this case did a pretty solid job. He did a pretty good job, and I put this not in the report in red not because I'm trying to take away from the job he did, but just because to show that even a conscientious police officer will miss things, and it's important to draw those details out as soon as you possibly can and record them in some way that you can provide them to defense and use later on. So when I asked him what her demeanor was like when we came for the hearing for bond, maybe just a couple days after this incident occurred, these are the exact words he used for her. She was visibly trembling. That's how frightened she was. In his report, he just says, well, I got there and I talked to her. He doesn't mention anything about her demeanor, but her demeanor is obviously extremely important for the statements that she made in the 911 call, if you want to get those admitted into evidence, and for To prove her state of mind when you're trying to set up your forfeiture case. And I just put visibly trembling hand wrote that into my copy of the report, so I didn't have any discovery issues. For the defense counsel, it was always right before them, and they were able to follow along with that when we presented that evidence to the court. And the judge, so it was Judge Jeanette Irby in our case, found that testimony very important, and we were able to get that recorded early on so that his impressions of her demeanor on scene hadn't faded with time at that point. So you see on the screen there on the slide that the oldest child basically immediately, he said, "I'm 5, my dad is 40, and he's dangerous." That's the sort of thing that a lot of police officers would not record. And at this time, the Loudoun County Sheriff's Office did not have recorders, body camera recorders at all, and many of the vehicles did not have recorders either. However, in this case, there was no vehicle recorder either. So the fact that he made these records in his police report became extremely important. A lot of police officers would hear this statement and they would not put it in their report because it's almost certainly not admissible in the case in chief. It's hearsay, and it's a child who is 5 years old, so we're almost certainly not going to be putting that child on the stand to testify to it himself. However, hearsay is admissible when you're putting on your forfeiture case. Might not be admissible at trial, but it's certainly going to be admissible when you're trying to set up that atmosphere of domestic violence that the defendant created, and that is the reason why your victim is not cooperating with the prosecution. So the fact that he put that in there and recorded it so precisely in quotation marks with that child's exact words was vital. And that's another thing that Judge Irby really zeroed in on when she was making her ruling. It shows, it's hard to imagine a better atmosphere, a better proof of the atmosphere of fear and abuse and how thoroughly it pervaded the home than a 5-year-old child being willing to say something of this nature about his father. And it's even more powerful that it didn't come from anybody asking him. He just said it himself. It's an unsolicited comment. So the officer then asked the victim about what happened. And she gave this account of events, that Mr. Cody had confronted her about his suspicions regarding her fidelity, that she'd been cheating on him at work. She denied it. As things usually went, he started to get violent. He strangled her until she lost consciousness. When she woke up, he punched her repeatedly in the chest, stepped on her back. And this was very similar to an incident that had occurred about 2 days prior to this. Now, this account of events is broadly consistent with the account that she gave on several different other different occasions, but because there were two that were so close together, the order and the exact nature of some of the things he did to her did get turned around, and that's something to expect, and it's also something that you can use to show at your forfeiture hearing how thoroughly domestic violence has infused and informed that relationship. When you're beaten up constantly, they're going to start to blend together. And so I think the fact that it was hard for her to keep track of which incident resulted in which injuries was, again, something that was very important. The officer was also able to record a number of other things, specifically the things that would not be admissible at a trial for the strangulation, but that ended up being very important for the forfeiture by wrongdoing hearing that we ended up having. So specifically, a lot of this is very standard domestic violence type stuff that you would expect to see, the power and control wheel factors. The most specifically that struck me were these statements that he had made about their children. What she was doing was it was her fault that he was beating her, and it would make him kill her, the kids, and himself. The officer asked her if he'd threatened the children before, and she said, well, yeah, especially the oldest one. and that was especially powerful given that she was later asking, as you can see, for leniency because he was such a great dad to the children. A lot of times officers will not ask that kind of question from the victim, or victim advocates might not either because they don't think it's going to be admissible. And it's certainly true that that would probably not be admissible at trial, but it's still going to be very important to record these things for the forfeiture hearing. The officer made some observations of his own. We noted again, I've already laid on how important it was that we were able to get him to describe her demeanor while it was still fresh on his mind, this visibly trembling statement. He did note that unsolicited comment to the child. He noted these bright red marks around her neck and ears and very heavy bruising across the top of her chest. Now that bruising we're going to see a photograph of in a few minutes, but the red marks around her neck and ears was important because by the time we got her to the forensic nurse examiner, those marks were not particularly bright or noticeable. Obviously, the nurse did a very good job, which we'll talk about also in a few minutes. But to be able to say that, look, when I had just gotten there, and this was all very fresh, within 20 or 30 minutes of the strangulation, she still had these bright red marks, even though when the forensic nurse examined her, those marks had faded a lot. That ended up being very important. And then my very favorite thing about this officer's investigation, he offered her the forensic nurse exam. If the difference between prosecuting one of these cases without a victim's corroboration with a forensic nurse exam and without a forensic nurse exam is incalculable. The forensic nurse exam in this case, like in many other cases of this type that we've had, was basically the make or break. So that was very important. This is something our forensic nurse examiners do in our jurisdiction. They have the victim demonstrate the manner in which they were strangled. They've got this strange sort of long-necked, bald head doll, and they just have them show so that they can demonstrate, well, look, he was hooking his arm around my neck from behind, or in this case, he used both hands while he was sitting on top of her. That not only helps a jury visualize what happened when normally they're just having to listen to someone talk. This gives them a picture to put to those words. But it also, if your victim is not testifying at all, it takes away a lot of the issues you might have with, sure, there were some marks on her neck, but was that really an attempt to strangle her, or did that just happen in the course of a struggle or a mutual fight? And so this clearly demonstrates that that's not what we had going on. This next picture is a little bit hard to look at, so you may want to glance away for a minute. But this is some of the bruising that she had on her chest. You can see a very clearly defined boot print there on the left side, the right on the picture. And she was unclear as to whether these bruises came from the incident 2 days before or the incident that day. I think they look old to me, and the judge remarked that she thought they were old as well, and that further showed the history of violence that had resulted in her not testifying. But we can flip on to that next one. Those photographs were both taken by the forensic nurse. The forensic nurse also got another account of the incident from the victim, and again, it was broadly consistent. There were bits and pieces here and there that got turned around. Order of events got turned around. Did he punch her on the chest? Did he step on her back or her front? These things were a little different, but again, I think that made the case stronger rather than weaker because it was so difficult for her to separate the many abusive acts that he had perpetrated. She did a danger assessment. A lot of jurisdictions have these. Our jurisdictions recently started doing the Maryland lethality assessment protocol, which is substantially the same as the one that the forensic nurse exam did. That's also something that we were able to use for proving that history of domestic violence, because that includes questions like, does this person manipulate you? Does he attempt to control the finances? Has he strangled you in the past? Do you have children that are not his? Have you left him after living with him and then come back to him? Things like that we were able to use to show the to show the abusive relationship. Now, this ended up being extremely important in this case, and extremely important in a number of other cases. This forensic nurse was able to articulate a need to know the identity of the perpetrator as a medical fact. Federal Rule 803 subsection 4, which is substantially the same as the Virginia rule, says that statements made for medical diagnosis are admissible hearsay if reasonably pertinent to medical diagnosis or treatment. So typically that's been held to exclude the identity of the perpetrator. The courts have held that if it doesn't matter to the doctor who caused the injuries, it just matters that the injuries were caused. So we could say she was strangled, we could say she had been beaten, but we weren't supposed to be able to say Kevin Cody did it because it didn't make a difference to treatment. However, this forensic nurse was able to enunciate what you see on the slide. She said, look, strangulation requires very attentive and detailed follow-up. It can result in long-lasting effects that might not be immediately noticeable to the patient, but would be to someone who is keeping an eye on her. And so advising her and and knowing who is keeping an eye on her and that that person is reliable was necessary for her to treat her patient. And in this case, it was necessary for her to ensure that Rain went home with somebody who could be relied on to do that, significantly not the person who had caused these strangulation injuries in the first place. Our judge rolled with that hook, line, and sinker, and the Court of Appeals, unfortunately, did not make a ruling specific to that, but did mention that that had been the reasoning and seemed to approve it. So that's a factor we may have to litigate later on, but I have since made the argument in many other cases and have never gotten a bad result about it. We also have in our jurisdiction a domestic violence follow-up detective. In fact, now we've got two. Well, at the time we just had one, who would go through particularly felony domestic violence cases, would go and talk to the victim, provide them further information, take new photographs of injuries, because particularly bruising often develops. It looks a lot worse a day or two after the incident than it did the day of the incident. These things take some time to develop. And also to get other information about the history of abuse. In this case, there weren't any prior police reports or prior charges that had been brought against Mr. Cody. However, often that is something that the follow-up would reveal and that we could use. So she was able to again get that account of what the victim says happened. She was still cooperative at that time. She was able to get some additional photographs of injuries, which the judge was moved by, and she was able to get some additional information about prior acts of violence and manipulation. These threats of suicide, of course, are a very common source of manipulation, of manipulative behavior, and she played for this detective. Rain played for the detective a voicemail that he'd left, saying he couldn't believe she was doing this to him, and he was going to go kill himself. He ended up not killing himself, of course, but that voicemail and that detective's testimony about the voicemail was again something that the judge focused on when she was giving her ruling, to show that this man has used his position in this relationship to dominate the victim. Now, jail calls are, of course, a domestic violence prosecutor's very best friend, because when a person gets arrested for domestic violence, more often than not, the very first person he calls is the victim, because that honeymoon period after an act of abuse, when he says he's sorry and everything's going to be great, that's a pattern that they find just as hard to get out of as the victim does. After they do something awful to the victim, they call them, they talk to them, they tell them that they're so sorry and it's never going to happen again, and they get forgiven, and they're used to this, so that's what they do. So in this case, that's sure enough pretty much exactly what he did. Mr. Cody was, I don't want to say smart enough, but he was aware enough that we recorded his phone calls that he did not call Rain from his own inmate account. He called Rain from one of his cellmates' inmate accounts, individual by the name of John Halte, and we only found it, we found it kind of fortuitously. I was listening to the calls he did make from his own account, and he mentioned to his father that he had talked to Rain. Now, I had listened to his calls and he hadn't talked to Rain, so I asked the jail coordinator to run a search for her cell phone number, Rain's cell phone number, and see what calls have been made to that. And we found a lot of calls from this other inmate's number, and we were able to find that it was actually Kevin Cody who had called her from that. So that was revealed that way. He initially called her in Virginia. When an arrest is made for a domestic violence offense, an emergency protective order is automatically issued, but it's only valid for 72 hours. The victim can then extend it to a preliminary protective order for 2 weeks, at which point there is another hearing to make it a permanent protective order. The Rain did extend for her 2-week protective order, but by the time that expired, she no longer wanted a protective order and did not extend it to a permanent one. However, the protective order was still in place when Mr. Cody made these calls to her. So we were also able to get him convicted and get a lot of suspended time on 5 counts of violating a protective order, which were easy cases to prove, of course, because he's there recorded talking to her in violation of the protective order. That was something we could go to trial on the strangulation and the domestic assault and battery and think, well, even if the jury or the judge dismisses those cases, we've got these protective order violations in the bag. They're easy. Rain made a lot of statements that we were able to use in our case in chief in the trial, which I've recorded here. So I'd like to go ahead and play that first call. These are just segments of the calls, not the full calls. The full calls are extremely long, and most of them are not really relevant. But I'd like to go ahead and play this first clip, and then we'll say a few words about that afterwards.
Came for a week.
You said the word magical. Do you remember that?
No. What did I say?
You said that not only did you think things would be good between us, you thought that it could be magical. You were right.
But I wasn't, because I didn't do anything. I didn't do anything that day that I came home. I was late because of the reasons I told you I was late. I didn't do anything.
Rain. Stop.
So a couple of things about that call. You'll notice that at no point does he admit to strangling her, and at no point does she accuse him of strangling her in that call. However, it gives us a lot of evidence that we were able to use. First of all, the call itself is just admissible. I argued, and successfully. It's just admissible because it is a statement of a party opponent, namely the defendant. And you can't make sense of the defendant's statements without also admitting the statements the victim made, which prompted those statements from the defendant. I've never had a judge refuse to admit the entirety of a call, assuming it's relevant, because of that argument. Second, Rain, I think it got a little cut off at the beginning, but Rain tells him, look, I couldn't swallow without pain for a week. So she doesn't say, you strangled me, but that fact is something that the forensic nurse was able to testify to as something that is a very common symptom of a strangulation. It's not only a common sense symptom of strangulation, that when someone strangles you, your neck hurts, but it's something that the nurse was able to say, yeah, I expect that to happen if what the victim says happened is really what happened. We get another thing we get out of this is that, again, that domestic violence honeymoon repenting and apology, telling her about how great everything's going to be if only she can forgive him. And then lastly, we get that corroboration of what she said. She told the officer and she told the forensic nurse, I was late coming home from work and he assumed it was because I had been cheating on him. And she tells him, no, I was late because of what I said I was. And that, again, you get not just that sort of cold, detached testimony of someone on the stand. You get that passionate, that adamant, emotional statement from a victim as she's justifying herself. That can be very powerful. So now we can go ahead to that second clip, if we could play that.
Do you know why I did what I did?
I'd like you to tell me.
Because if I didn't, you were going to kill me.
Wow, right? How much more powerful can you get? She has experienced abuse from this man to the point that she is morally convinced that he's going to kill her unless she leaves him. And even though by the time the case comes along, the trial comes along, she's no longer feels that way. The fact that she felt that way a couple of days after the incident speaks volumes. And it may not speak volumes in terms of the case in chief, although arguably I think it's relevant for that as well. It certainly speaks volumes when you're trying to say this domestic violence atmosphere that the defendant has created is the reason that she is not testifying. And the next clip, please.
You know, I spent 4 days in a shelter because I didn't know where you were, and I was scared of you.
Same kind of principle there. She won't go home, even though he's running. He was kind of on the lam for 4 or 5 days before he was arrested. But she doesn't know where he is, so she won't go home because she's so frightened of him. And then the last clip.
Let me fix my family.
Do you have any idea how scared I've been of you for years? Do you have any idea?
And that, especially that for years. The emotional power of that statement, of course, is significant. You can really hear the misery in her voice there, but also the fact that she says for years, again, establishes a long-standing pattern of abusive conduct rather than just a one-time abusive act. So those are the statements that she made in those calls that I really laid on as thick as I could with the judge. We're going to listen to a few that he made. These are obviously I've divided them up into manipulation and obstruction. Statements that he made to her that were just manipulative, trying to persuade her not to cooperate, trying to persuade her to take him back, forgive him, say it didn't happen. And the obstruction are the ones where he says, drop the protective order, drop the charges, don't testify, don't come to court. Obviously, there's a lot of overlap here. So I'm identifying clips based on what I think is their primary purpose. So let's go ahead and play that first one there.
If you don't give me another shot at my family, I might as well be dead.
And we've all, anyone who's done this kind of work for more than a week has seen abusers pull this, because the victim really loves them. Rain really loved Mr. Cody. Rain's a much better person than he is, and so them being in danger is something that really powerfully affects them, and the abusers know this and use it against them. We've already heard about the voicemail threatening suicide that we were able to use from the follow-up detective. He says that sort of thing multiple times. This is just sort of the most representative. Let's go ahead and play that second one.
Do you know that I wanted to propose to you?
Yeah, and again, look, not only is this never going to happen, but I'm doubling down. I'm gonna be true to you. I'm gonna treat you right. I want to marry you. And at the time, fortunately, I didn't include this part. Rain was very dismissive of that, but they've since gotten married. When he was released from prison, they did marry, and that kind of statement is another thing the judge really zeroed in on, and that I think you can profitably argue. Let's go ahead and play the next one.
And I have to move forward on the path that I've already chosen.
No, you don't.
I'm not. Yes,
you don't
I do.
have to.
Yes, I do.
Listen.
For my own peace of mind.
No, you don't.
Listen,
it's not going to be peace of mind for you. I'm telling you, this will haunt you for the rest of your days.
Yeah, it says not a lot of commentary needed on that one. It's just, look, if you don't stop this, you're going to be miserable. But as we just talked about, if you come back, let me come back, and you make this go away, things will be magical, just like you always hoped they would be. We can go ahead and play the other two, I think, together.
It was, sooner or later, they'll have to kill me.
No, they're not going to kill you.
Or they'll let me out. Or they'll let me out and I can do it myself. Please remember what our family was like when it was good, because it will only be that good and better. Please remember me, for real. Remember the good. Remember who I was. I promise you, it's better. One chance is all I need.
Yeah. So again, the threats of suicide and the one more chance, we can fix this, it'll be great. Just literally textbook manipulation. And I see now that I didn't put this recording in, but at one point, Rain actually tells him, do you understand that how textbook everything you're saying is? And so even being aware of the pattern of manipulation that he was levying against her, she still went for it eventually, which just goes to show how powerful these methods are, and how frightening that is for people who do what we do. Well, we have to be aware of that, and we have to make our first responders especially aware of that, because it's easy to get burnt out, and it's easy to get discouraged, and we have to remember that those victims are working with something a lot more difficult than we are. So here are some of the calls that amount to obstruction. I think let's go ahead and play the 3 calls about dropping the protective order together if we can.
All I need from you, Rain, is one chance. And I can beg, I can tell you more stories, but there's nothing that's going to stop this from being what it is. You putting your faith in me, in their father. And I promise you, you will not be disappointed. You use the word magical, and I'm telling you, that is coming. Please, I need you to do 2 things. I need you to get the protective order annulled or whatever, let go of that so that I can.
The jail administration has disconnected your call.
Drop charges. But I need you to take away the restrictive order that says I can't contact you.
No, there is going to be a court date. There's still going to be a protective order, but you can contact me.
I need you to drop the whole thing.
Yeah, so you can see how much difference the protective order made for him. He was calling her all the time anyway, but it was important for him that he get that extra step. If he might not be able to convince her to just recant or to attempt to drop all the criminal charges, but the protective order seems like a much smaller thing. So rather than shooting for a bridge too far, he shoots a little closer and can work up to it. And that's of course exactly what happened. She first dropped the no contact provision on the protective order and ended up dropping the whole protective order, and then asked us if we would drop all the criminal charges. You'll also note he uses the children as a means of manipulation as well. And that's obviously very common, threatening or using the needs of children or pets against the victim by an abuser. But I'll note, in all this time he's speaking to her, he never once asks if he can talk to his kids. At that point, I believe by the time that last call, he had been in jail or away from the home for almost 2 weeks. So had not spoken to the children at all, and never once asked to talk to them. So it's obviously the needs of his children are only important insofar as they furthered his goals with her, but he still used them, and eventually it did have the effect he was seeking. And so, of course, the thing that really made this the case that we wanted to push to the Supreme Court, to the Court of Appeals in Virginia, are these next three calls. If we could play the drop the charges, beat the charges legally, and don't testify clips.
There's still going to be court dates.
You can drop charges. You cannot show up. And to drop charges. And just because you drop charges doesn't mean that the charges won't go through. It just makes it more likely for me to actually be able to beat the charges legally. It doesn't have, I mean, you don't have to drop anything. You could still testify against me. You could still try to,
I have to. I've been subpoenaed.
You don't. You actually don't. I've talked to people, and you don't.
So that last bit there, I've talked to people and you don't. At least in our jurisdiction, we'd been trying to push cases without victim testimony for a while. And we tried a lot of different things. And at this point, we were getting a lot of victims retaining counsel and pleading the fifth. Unfortunately, that leaves us with very little option when they have counsel. Sometimes if they try to plead the fifth without counsel, a lot of people think pleading the fifth just means I don't want to testify. They don't think you need a basis for that. And we're able to compel their testimony anyway. But when they have an attorney, our judges at least aren't really willing to inquire as to why. They will take it for granted that the attorney has verified that they have a reason to plead the fifth, and that's it. And so in this case, that's what Rain did. She retained an attorney and said she would like to plead the fifth. The attorney wrote us a letter. I asked him if he could put it in writing, and which he agreed to do. That she did not want him prosecuted, and she was going to plead the fifth. And I did put her on the stand for the preliminary hearing, just long enough for her to say I plead the fifth. And actually ended up doing the same thing at the trial, just so she could say I plead the fifth. And I could establish on the record that she was unavailable, because claiming of a privilege does make you unavailable, at least according to Virginia case law. So looking at all of these things and reflecting back on those three elements that we reviewed early on, that Josh reviewed with you, that the witness be unavailable to testify. We had that because Rain pled the fifth. That the defendant caused that unavailability, and that he did so with the intent to prevent her testimony. The way we were able to prove those second two elements was entirely with facts and circumstances evidence about the abusive relationship. And so building that forfeiture case required a lot of attention to detail by first responders, by the forensic nurses, and by our victim advocates. And so here, I think Josh is going to jump in again as well, and the two of us will go over the rest of this together. Josh, do you want to say anything about the attention to detail?
Yeah, absolutely. So, when I think this really goes to the first responders, really everyone but the lawyers who are listening to this. Because, I mean, the lawyers, you're going to be putting it together at the back end, so attention to detail is important to, not just gloss over reports, not to just ignore available evidence like jail calls or letters or that sort of thing, but still, really, this is building the forfeiture case. It starts with the first responders, and that's the most important part of all of this. So when we have a successful forfeiture, it's because our first responders, our forensic nurses, and victim advocates, those are the three main ones, but really anyone who interacts with the case, it's because they were attentive to details. They really paid attention to the training they received for domestic violence cases, and when they arrive on scene or when they interact with the victim, they're looking for specific things. So for law enforcement, I would encourage you, when you're pulling up to a scene, look at your CAD notes, whatever system you're using, to see, have there been prior calls to this address? Have there been prior charges involving these individuals? If so, when you talk to your victim, ask her about them. And I think it's important to point out, especially for these first responders, that chances are that when you arrive on scene, this is going to be the most cooperative the victim is ever going to be in the course of the entire criminal prosecution. I think we've all seen it over and over again on scene. They want them arrested. They're angry. They'll tell you everything about how he does this, how he does that, how he abuses her. Sorry?
They're angry or frightened.
Or frightened, yeah. I mean, it can be, runs the gamut of emotions too. Sometimes simply just sad as well that it's all come to this. And this is when you really have to take advantage. And when you first roll on scene, as Don pointed out in the Cody case, officers walk in and this kid just says, his name, and says that he's 5 and his dad's 40 and his dad is dangerous. These are incredibly important details to point out. Looking at the demeanor of the people on scene, specifically the victim, but children as well, making notes of that. When they make statements, do they simply say things like, "He tried to kill me," or do they come running out of the house screaming it and crying? These can be incredibly important for just general evidence-based prosecution. Is that an excited utterance, or is it a statement that was made in response to a question? But getting those kind of that flavor, I would say, of what is really going on at the scene can help many months later when your prosecutor is trying to put together that forfeiture in court. So talk to the victim, ask her about prior abuse. And especially if you see those prior calls that were made, ask her what happened. Because again, this is when she's cooperative, and she'll tell you, yeah, he hit me then too, but I didn't end up going to court, because he, promised he would never do it again, or he, threatened to cut me off financially, or, he said he'd take the kids away. Sometimes if you're dealing with immigrants, sometimes, a lot of times the abuser has, better legal status than the victim. So, he threatened to get me deported, told me I'd never see my kids again. Pets are a big deal as well. You see pets running around and you have domestic violence, I guarantee that pet's probably been involved in it in the past too. A threat to kill the dog or the cat or to keep it away. Ask about those sorts of things, and really listen and take good notes when they divulge those sorts of things to you, because as we'll get into in a little bit, those things can then be used quite effectively in a forfeiture by wrongdoing motion later on in the case. And then I think this is just generally good advice, but it can't be said enough. Take great notes and write detailed reports. If you're ever sitting there thinking, should I put this in my report or not? The answer is yes, put it in your report. I would always rather have too much information than not enough. I've never complained, seriously complained, that an officer put a detail in his report. I've certainly complained when details weren't in them. If you can, get the victim to write a statement. Again, while she's cooperative, while she can give you those details in her own words. If you have body cam or the ability to record things, do it. Because again, you may end up being the key witness in the case. If the victim just never shows up for trial, we're not going to be able to put her up there to ask what happened. And, many months later, you might be the key witness in the case, not only for the forfeiture, but then also what her actual allegations against him were. So take a good report, keep detailed notes, and if you can, record as much as possible. And, keep in mind, too, that your testimony will be important for the forfeiture motion, mainly because, as Don said, and I think this is worth stressing over and over again, hearsay is admissible to prove the forfeiture. So, and by that, what we mean is, let's say that our victim doesn't show up to court, but we have her best friend or her sister, who hates the defendant with, the fury of 1,000 suns, and she is more than happy to cooperate with the prosecution because she's worried about her friend. And so she comes and she tells you, listen, she's not going to be here, but I was talking to her. I was encouraging her to come. And she said, no, she's not going to come because the defendant told her that if she does, he's going to take the kids away. Now, normally that's a hearsay statement through and through, but the case law is clear that you can use that hearsay statement to prove the forfeiture issue. So be aware of that and take good notes about those sorts of things as well. And on that note, talk to family and friends. Because again, a lot of times the victim becomes uncooperative, but the victim's friends, family, they know what's going on and they want it to stop. And they are more than happy to help you out, even if it makes her angry. So let's go back to the elements a little bit of forfeiture and talk about how we prove each of those elements. So first off is unavailability, and we'll get into, again, more detail later on of exactly about what counts as unavailability, but really what you're going to run into the most often is your victim just simply doesn't show up. You send a subpoena, maybe it's personally served, maybe it's not, but you get her under good process, so she just doesn't show up. So that's going to be your usual situation. So the next question then, let's say you have that, you've proven unavailability. That's easy. But you've got to prove that. Sorry, go ahead.
No, go ahead, Josh. You were leading where I was about to go.
Okay. So then the question is, how do you prove that not just that she's unavailable, but it was the defendant who caused her to be unavailable? Well, again, first and foremost, in proving this, again, the hearsay is admissible, but I would say there's some good sources of evidence to look for in this. First and foremost, jail calls. Those are a gold mine, as you saw from the Cody case. If you're not listening to jail calls in your jurisdiction, I know it's a huge undertaking, but find a way to start doing it, at least in big cases or where you start to anticipate you're going to have this issue.
And maybe not all the jail calls, if sometimes the volume is just too much, but particularly right when they're locked up and right around hearings. If you have to limit yourself, do that.
Yeah, absolutely. And I'll say, I don't know about other jurisdictions. I know now that I'm here in Kansas, it's a little bit different, but in Virginia, generally speaking, the person get arrested, they get taken before the magistrate and a warrant is issued. And along with the warrant, a protective order is issued, barring the defendant from having any contact with the victim, at least for 72 hours. And oftentimes, if they're booked into the jail and they make a jail call, they've just been served this protective order. The very first call they make is to the victim, and that's wonderful for you for a lot of reasons. Number one, it's a violation of protective order, so it's an extra charge. But number two, it shows the lengths that the defendant will go to influence the victim. He will even violate the law to do it. And I think, again, as Don pointed out, that was an issue in the Cody case as well, and the judge's determination that a forfeiture had occurred. And for the Court of Appeals, I think they latched onto it as well, that he even violated protective order in order to influence her. So that can be great evidence right there. Also, look and see, defendants have a right to the mail. And so you can get copies of letters. I mean, talk to your jail staff, whatever agency runs the jails, about getting copies of letters, because a lot of times they'll feel free to put that information, information they wouldn't put in a jail call, they might put in a letter, and that's going to be just as good. One thing that I'm excited about here in Kansas is we record everything that they do at the jail. So even face-to-face meetings are recorded. So if the victim goes to the jail to meet with him, that's even recorded. So there's a lot to refer to, but start to look at it all. And like Don said, focus in on right after he's arrested and right around important hearings, bond hearings, preliminary hearings, trials, that sort of thing.
And if you can set it up so that the mail can be requested automatically for certain types of cases, that can often be a good idea. Like in our jurisdiction, we have to specifically request it, and typically don't, except for the very biggest cases. And I'm often hearing in jail calls a defendant say, "Oh, I wrote you a letter." I'm like, "Well, great. Now it's too late for me to get it. It's already in the mail." Yep. So if you can get that to happen without your active intervention, that's definitely the way to go.
Yep. So then, let's say you don't have that kind of evidence. I would say that the next thing I would look at is, again, we talked about this earlier, was this the first time law enforcement or another agency responded to a complaint of violence between these people? And if not, look at those prior allegations, and hopefully, again, your first responders, your forensic nurses, your victim advocates, when they've talked to them and while they were cooperative, they asked about those things too, because that can be crucially important, because they may tell you in the past he's gotten her not to appear. And I think it's not a big leap then for the court to make an inference. Well, he's influenced her in the past not to appear. It's probably what's happened this time. It's a good piece of evidence. So look there. And let's say you don't have that then. Look for evidence of control. And this is just your classic DV power and control wheel. We didn't even bother to put it in here. I think everybody has it. Everybody knows about it. But it's so ubiquitous because it's so on point. And it has all of those little ways in which an abuser exerts that power and control over the victim. So look for those signs. Is he exerting financial control over her custody, control of the pets, sexual abuse, isolating her from services, from her own family and friends, those sorts of things, because again, those will be excellent sources of information. If we can go to the next slide, because this goes right into the next point, which is that especially in cases of domestic violence, forfeiture by wrongdoing is even more an available option. And I think this is just worth reading. This is from the case of Giles v. California of the United States Supreme Court. It's 2008. It's only 11 years old. The domestic violence context is, however, relevant for a separate reason. Acts of domestic violence often are intended to dissuade a victim from resorting to outside help and include conduct designed to prevent testimony to police officers or cooperation with prosecutions. The case goes on to say that, especially when there's a fatality, so if you have a domestic violence fatality, you may be able to get a forfeiture out of that as well, because the court almost, and Don, correct me if you think I'm selling this a little too much, but almost says categorically, when you've got that history of domestic violence and instant homicide, you almost categorically have a forfeiture by wrongdoing.
I'd say almost. I think that's right. But
yeah, almost.
This is the Supreme Court of the United States explicitly saying the domestic violence context is relevant. So that means at your hearing, anything that relates to that domestic violence context, anything that goes to that power and control wheel, it's all admissible to determine forfeiture.
Absolutely.
So lay it on as thick as your judge will let you lay it on.
And also, a motion like this is a great opportunity to tell the judge, if nothing else, and you're probably not going to be able to put all this in front of the jury. Some of it you can, and we'll get to that, but at least tell the judge and put them in the frame of mind that this isn't just one bad night where law enforcement showed up and maybe he had a little bit too much to drink and he regrets it. This is the life that this victim is living, and it will help flavor everything for that judge and hopefully convince them that, that he really is in control of the situation. He's the reason that she's not showing up, that she's unavailable. And finally, on this element, keep in mind that you don't have to prove that he's the only reason that she's unavailable. You'll need to prove that he's a reason that she's unavailable. And I think, again, Don, you hit on that in the Cody case. I know it was an issue, in that they had alleged that she had already decided on her own that she was going to plead the fifth. And the court basically said, that may be true, but he also put that idea in her head and encouraged her to do it. So he's certainly a reason that she was unavailable. So don't let defense kind of weasel out of it by saying, oh, she probably wouldn't have testified anyways. It doesn't matter.
And that's correct. And there's no shortage of cases where they will note, like, even if the victim had decided for reasons of her own, I don't want to cooperate with this, I don't like driving to the courthouse, whatever it was, as long as he is a contributing factor, that's sufficient.
Yep. So the next element is, that last element is the intent. It's not, again, just enough to show that he caused her unavailability, but he had to intend to make her unavailable. And honestly, what's on this slide says it all. It's a pretty simple element to comprehend, and I don't think there's a lot of complicated case law on that. Would you add anything to that, Don?
No, not really. And I think once you've put on all the evidence that the defendant caused her unavailability through the domestic violence context, I think you've more or less proven this element as well. because it's precisely
Absolutely.
that context that makes it relevant for why she's not there. And like in the Cody case, that was the whole. We had no instance of Cody saying go and plead the fifth so you don't have to testify. But we were able to show, look, she had given these consistent statements of what happened. She never gave any statement that implicated herself in any kind of criminal act. And the defendant had created this miserable domestic violence environment and wore on her until she finally gave in. And that was enough to prove his intent.
Absolutely. So I think that the next thing is, forfeiture by wrongdoing. I think if you'd ever been to one of our other trainings that we've done on this, Don gives a great history of it, and it goes all the way back to Sir Walter Raleigh. It's an old doctrine, but I think there's still we think there's still a ton of work to be done, and pushing the boundary on this even further, especially now that domestic violence is getting a lot of scientific research and a lot of attention drawn to it, to be able to see that the actual root causes of it and what it is at its heart. And I think there's starting to be a more understanding in society that it's not just a matter between a husband and wife or a boyfriend and girlfriend that the rest of us should just kind of keep our noses out of. So I think the opportunity is in front of us right now to really push forward on this. But before I even get there, I want to just say, if you get your forfeiture or you think you have a case where you can get it, really push for it. Even if you think, maybe there's a chance my victim will show up, or maybe my victim will be somewhat cooperative. Even if you think there's a chance, I would say still prepare for it, because a couple of things happen when you are successful with the forfeiture. First of all, as we said before, it's its own hearsay exception. So you don't have to worry about these prior statements that the victim may have made to law enforcement, and trying to find some other exception to get them in, or worried that she's not going to say it quite as well on the stand this time, as she said it to law enforcement. Then you're just able to introduce those statements, just for the truth of the matter they assert, full stop. So it's a very powerful tool.
And sometimes, in fact, it's so powerful that it's better for your case if the victim is not available. And you can make those, and you can admit the evidence under this theory, because the breadth of what you can admit is significantly greater, and you don't have to worry about minor inconsistencies and things of that nature that often come up with live testimony.
Absolutely, and I kind of expanding on that point then too. We can admit to ourselves that a lot of our victims just don't come off as sympathetic to a jury sometimes, and that's unfortunate. But forfeiture by wrongdoing, if your victim's not even there or otherwise unavailable, then you don't really have that issue, because you're able to put the victim before the jury, kind of paint that picture yourself. They're not necessarily going to see her on the stand, if she's the kind of person who drops casual profanity here and there, or is going to fly off the handle at defense counsel. None of that's an issue then. So honestly, sometimes your case is better without the victim there, and this is a tool to be able to push forward even without her then, and maybe even make your case even stronger. But then on the kind of legal pushing forward, and this is one big area that we've been really looking for that perfect case to test. And so I would put it out there to all of you listening, to really take this up and see if you can make some great law on impeachment. I think most states, and I know the federal rules, I know Virginia and Kansas to some degree, you've got to confront your witness with impeachment evidence, to at least some degree, at least get them to acknowledge it, to give them a chance to explain, especially prior inconsistent statements. And so if they're not there to actually explain away or to acknowledge that statement, then at least there's an argument that they can't even be impeached. Now, again, the federal rules, and I think if we could go back a slide, the federal rule 806, and then I know Virginia has a similar rule, and a lot of states do, that allow for impeachment of a declarant when hearsay is offered. And so this would seem to argue against everything I just said along those lines. But I think, again, the very same principle that underpins forfeiture by wrongdoing, I said it earlier that a person can't profit by his own evil act, or sometimes you hear it called, approbate and reprobate, that a defendant can't cause a wrong and then take advantage of that wrong that he caused. So, the Federal Rule 806, which I think is again adopted and probably by most states, because most states adopt the federal rules to some degree, they say that you can impeach that declarant just as you could as if they'd taken the stand. But I think, argue to the court that no, this would be a case of approbation or reprobation, where the defendant is getting around his normal obligation to confront the witness with the impeaching information, and he's getting around it because of his own wrongdoing. He's the one who made her unavailable, so he can't then profit by that. And you could maybe even argue against even impeachment of the statements that you put forward. So something to consider. Then next, do you have any other ideas in terms of that, Don? Anything else you want to say in terms of impeachment?
Not on that. I think.
Okay.
I think you've covered that pretty well.
And I think the final issue that Don and I have really been pushing on is, again, this notion of what does it mean to be unavailable. And again, we talk about the classic instance is the person just simply doesn't show up, and that's easy. And then in the Cody case, the victim was pleading the fifth, so she was potentially able to be there, but you call her to the stand, she's going to plead the fifth, and that's going to be the end of it.
In fact, that's actually what she did. She was physically there, but because she pled the fifth, her testimony was unavailable.
Yep, and that's, I think, in most states and the federal rules, federal case law, that's what they talk about. It's not so much that the person is unavailable, like physically unavailable. It's their testimony is what we care about. Is their testimony available to the calling party? And so, here are some, other examples. Federal Rule 804 has a list of things that can make a person unavailable. But some of the classic ones are, they assert a privilege, such as pleading the fifth, or they're outside of the jurisdiction. So, we can't even subpoena them because they've gone to Cuba or something like that. Or they just simply disappeared. I've certainly had those cases where your victim's just gone. And I think that happens a lot in cases where you're talking about people who are immigrants. Sometimes they have an ability just to vanish into the fabric of society. And so it becomes difficult to locate them. That can make them unavailable. So long as you can show that the defendant caused that to happen or encouraged that to happen, you have unavailability, you have your forfeiture. A couple of issues I know in Virginia, and my very first success in court on forfeiture was where a victim took the stand and very obviously was lying about not being able to remember the facts. And the court agreed with me that he was feigning a lack of memory, and it was because the defendant I had jail calls where he'd actually told him, hey, just say you can't remember. And so the court allowed me the forfeiture in that case because it said he's unavailable to you because he's acting like he doesn't remember.
No.
You sound like you have something to say there, Don?
Yeah, and that's just to reemphasize that. There's case law in Virginia, and I cited it there, but I'm sure that other states have similar things. The victim, it's not the witness that we're really worried about. Now, if the witness is unavailable, then of course the testimony is also unavailable, but the testimony might be unavailable even if the victim's physically present. And so
Absolutely.
that's a boundary we've been trying to push forward. It's like, well, so if the victim's feigning lack of memory, testimony is unavailable. What if the victim's just straight up lying, like obviously provably lying? That's the sort of theory we're trying to push forward that I think some of the next really big forfeiture cases are going to be about.
Yeah, and I think it's the big new frontier. And then Donna, I've always been looking for that perfect case on the obviously lying. And I would say look at your rules of evidence too, because I think a lot of judges are going to be hesitant to say, well, I'm not going to decide right now that this witness is lying. That's the province of the jury. But a lot of the rules, for instance, in Virginia, there's a hearsay exception for prior unadjudicated perjury. And in that exception, it actually says that the court has to first make a finding that the witness on the stand has made a material misrepresentation of fact, that he's lied. And so if you look through your rules, look through your case law, I'm sure you can find in every state, in every jurisdiction, situations where the court has to make some kind of judgment call on a witness not being honest. And once you've established that they have that power, then what is the difference between them asserting privilege or refusing to testify and just simply lying. The testimony, the actual honest testimony, is still unavailable, and if you can show it's because of the defendant, you should have your forfeiture. But look for those sorts of issues and really push the envelope on those. I mean, what do you have to lose is really the issue here. A lot of times in these cases, but for, crazy ideas, you might as well just dismiss them because you don't have anything to go on. So you're playing with house money.
So Josh and Don, I hate to interrupt, but we are out of time. So I'm going to give you 1 minute to wrap it up.
All right. Well, thank you very much, Gail, again. We actually reached the end, so I think the timing was perfect on it. I would just, again, encourage people to try new things, try out crazy things. A lot of these cases, they wouldn't go anywhere if you didn't, push the envelope. So keep going for it.
Okay. Well, thank you very much. We've got now a nice slide on how to reach the two of you. If you could go ahead and advance to the next slide, I will wrap things up. Definitely a thank you to all of you, not only for your leadership and taking on this issue. Since the Crawford case happened, I would say in 2004, we had complete chaos for a number of years, but to see what you're doing in this community is just giving me a lot of hope. And I think the other thing that came out of this presentation in particular, how it is a community effort and the whole community does need to work together as a team. I know people will be asking about motions and we will be adding more materials. I will also add Meet Me at the Hill Where We Used to Park is an excellent tool for folks utilizing forfeiture by wrongdoing. I also want to give a final shout out to Scott Kessler from the District Attorney's Office in Queens, New York. He was one of the very first pioneers to really take this on in forfeiture by wrongdoing. He has trained hundreds and hundreds of prosecutors, but to see the next generation take this on and move it forward just gives me a lot of hope. And also thank you so much for so many practical tips. You gave me things that I didn't think about before that I'm definitely going to incorporate. Took a lot of great notes. And just want to share where others can get a copy of this as we download it. But please go ahead and send in your questions. Our team is not available to answer questions today, but they have agreed to answer questions and send their responses generally a week from the time that we do the training. I also want to thank Trish and Carly for managing today. It went very smoothly. No technology issues. I am healed. So the next slide, please. Just a couple of last minute things. Come join us in May. We will have our international and annual conference. We sold out last year. We have a whole session on strangulation and also a breakout on forfeiture by wrongdoing. Next one. We wanted to remind everybody about the next upcoming advanced course. The one in August is already sold out. I'm afraid to tell you that by the time we open up registration for October, it will be sold out almost probably within 24 hours. So because teams are just waiting for the registrations to open. So if you're listening and you want to be part of the October class, please submit your application as quickly as possible. It's really a fun course. October is going to be particularly special as we have a lot of international guests and visitors joining us. And then the very last one is where we started is always where I love to end, is honoring these two teenagers. They changed my life forever, and I'm glad they did. And I want to dedicate each and every training to them. When we get to do a training, a webinar, a course, a 4-day course, I feel like we live to our commitment to their parents and to their children that Cassandra and Tamara did not die in vain. And having this webinar about how a strangulation case was proven without the victim's testimony definitely is another way of sharing that commitment. So thank you, Alex, Josh, and Don, for your amazing leadership and hard work and dedication. You are my heroes. So thank you, and thank you all for joining us. This now concludes the webinar.
Thank you, Gail.
Thank you very much.
Thank you.
Bye, friends.
Bye.
Bye-bye.